Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only. It does not constitute legal, financial, or professional advice. Divorce laws and mediation practices vary significantly by state and jurisdiction. The historical trends, potential outcomes, and case studies discussed are meant to provide context and are not a substitute for the counsel of a licensed attorney or a certified mediation professional in your area. Please conduct your own due diligence and seek professional guidance for your specific situation. Imagine for a moment that you are standing in a high-ceilinged, wood-paneled courtroom. On one side sits the person you once promised to spend the rest of your life with. On the other side, you sit with your own legal counsel. Between you lies a chasm of tens of thousands of dollars in legal fees, years of shared memories now reduced to line items on a spreadsheet, and the distinct possibility that a judge who has never met your children will decide when you are allowed to see them. This is the reality of the traditional adversarial divorce in the United States, a system designed not for healing or resolution, but for winning and losing. For nearly a century, the American legal system treated the dissolution of a marriage like a corporate breach of contract or a criminal trial. But what if the most significant innovation in family law over the last 100 years wasn't a new law, but a new way of talking? Today, we are embarking on a deep dive masterclass into the history of conflict resolution, specifically focusing on the evolution of divorce mediation in the United States. We are going to explore how we moved from a system of private investigators and forced testimony to a collaborative model that prioritizes the psychological well-being of the family unit. This journey is not just about dusty law books. It is about the intersection of labor strikes, psychological breakthroughs, and the slow realization that the standard courtroom model was failing the American family. By understanding this history, you will gain a profound perspective on how modern conflict resolution can save families from the financial and emotional ruin that was once considered an unavoidable cost of ending a marriage. We will look at the potential outcomes of mediation compared to litigation and analyze historical trends that have reshaped the domestic landscape of the U.S. To truly understand why mediation was such a radical departure, we must first examine the fault-based era that dominated the first half of the 20th century. Before the late 1960s, getting a divorce in most U.S. states was an exercise in character assassination. You could not simply decide to part ways because you had grown apart or were no longer compatible. You had to prove a fault. This meant providing evidence of adultery, extreme cruelty, or willful desertion. This legal requirement created what historians often call the divorce industry, where private investigators were hired to snap grainy photos of spouses in compromising positions, and witnesses were paid to testify to fabricated accounts of abuse. This adversarial system was built on the logic of the guilty party and the innocent party. The innocent party was rewarded with the assets and the children, while the guilty party was punished. In this environment, the concept of a neutral third party, helping a couple reach an agreement, was almost non-existent in the legal world. However, the seeds of mediation were being planted elsewhere. While the family courts were stuck in a cycle of blame, the American industrial sector was facing a crisis of its own. During the early 1900s, labor strikes were paralyzing the nation. The government realized that they could not simply order workers back to factories through litigation. They needed a way to facilitate conversation between two parties with seemingly irreconcilable interests. This led to the creation of the United States Conciliation Service in 1913, which would later become the Federal Mediation and Conciliation Service. These early labor mediators discovered that when parties were given a safe space to voice their underlying needs, rather than just their legal positions, resolutions were reached faster and with more long-term stability. The jump from the factory floor to the living room did not happen overnight. One of the earliest and most overlooked precursors to modern divorce mediation was the Conciliation Court of Los Angeles County, established in 1939. This was a response to the skyrocketing divorce rates following the Great Depression and the social shifts of the era. The court realized that many couples were entering the adversarial system without ever having a chance to explore if their conflicts could be resolved, or if their parting could be made less destructive. While this early model was more focused on reconciliation than mediation as we know it today, it introduced a revolutionary idea that the court system should provide a social service component, not just a judicial one. As we moved into the 1960s and 70s, the no-fault revolution, spearheaded by California's Family Law Act of 1969, changed everything. Suddenly, the legal requirement to prove a spouse's sin was removed. This shift created a massive vacuum. If the court was no longer there to determine who was guilty, then how were couples supposed to decide who got the house or how to raise the kids? The old adversarial lawyers were trained to fight for every inch of ground, but the new law allowed for a softer approach. This is where the true pioneers of mediation stepped in. Figures like O.J. Kugler, often cited as the father of modern divorce mediation, began to argue that divorce was not a legal problem to be solved, but a psychological and social transition to be managed. Kugler, an attorney himself, grew frustrated with how the legal system exacerbated the trauma of his own divorce. He founded the Family Mediation Association in 1975, introducing a structured process that blended legal knowledge with behavioral science. The data from this era began to show a clear trend. Case studies from early mediation pilots suggested that when couples reached their own agreements, they were significantly more likely to follow them. This was a stark contrast to court-ordered mandates, which often led to post-decree litigation, a fancy term for going back to court every 6 months because one parent refused to follow the judge's rules. The potential outcomes of these early mediation sessions weren't just financial. They were measured in the lower stress levels of the children involved. Researchers found that the conflict level of the parents was a higher predictor of a child's future success than the divorce itself. Throughout this series, we are going to break down the mechanics of how these pioneers built the frameworks we use today. We will look at the specific integrated mediation models that emerged in the 1980s, where mental health professionals and attorneys began working side by side. We will analyze how the 1990s saw a surge in mandatory mediation programs across states like Florida and North Carolina, as courts became so backlogged with domestic cases that the entire system was on the verge of collapse. This masterclass is designed to give you the deep dive context necessary to understand why mediation is now the preferred method for conflict resolution in the United States. We will explore the shift from positional bargaining, where each person makes extreme demands, to interest-based negotiation, where the goal is to find a solution that satisfies the core needs of both parties. By the end of this 10-part series, you will understand the historical architecture of the American family court, the rise of the private mediation industry, and how the lessons learned from a century of conflict can be applied to any high-stakes negotiation in your life today. We are moving beyond the surface-level advice you find in textbooks and into the raw, complex history of how Americans learned to stop fighting and start talking. Stay with us as we peel back the layers of the adversarial system and discover the origins of the peacemaking movement that changed the law forever. To understand the pivot point where the American family began to reclaim its own destiny, we have to look at the year 1974. Imagine a couple named Michael and Susan living in a suburb of Atlanta. It is the height of the mid-70s. The cultural landscape is shifting, and for the first time in United States history, the divorce rate has begun a climb that seems unstoppable. Michael and Susan are not just figures in a data set. They represent a generation that was suddenly allowed to leave unhappy marriages without proving a crime. Yet they found themselves trapped in a legal machine that demanded they act like enemies. In 1974, if Michael and Susan walked into a traditional law firm, they were immediately separated. Their lawyers would begin a process of discovery that felt more like an interrogation. They were told not to speak to each other. They were told that every concession was a weakness. This was the adversarial status quo. And it was into this high-tension environment that an attorney named O.J. Kugler stepped with an idea that would be labeled as heresy by his peers. Kugler is a central figure in this deep dive because his motivation was born from personal failure. He had been a successful lawyer, yet his own divorce had been a financial and emotional bloodbath. He realized that the legal system was fundamentally unequipped to handle the nuances of human emotion and co-parenting. He looked at the potential outcomes of the traditional system and saw only wreckage. So, in 1975, he did something radical. He founded the Family Mediation Association. This was the first time in the U.S. that a structured, non-adversarial framework was applied specifically to domestic relations. Kugler's brilliance lay in his rejection of the courtroom's geometry. In a courtroom, everyone faces the judge, the ultimate authority. In Kugler's model, the couple faced each other with a neutral facilitator sitting between them, not as a decider but as a guide. But how did this actually work on the ground? Let us break down the Kugler method, which became the blueprint for the next 50 years of mediation. Step 1 was the orientation. This was not about legal rights, it was about rules of engagement. Kugler required couples to agree to a set of behavioral norms before a single asset was discussed. Imagine if Michael and Susan were told that they could no longer use their children as messengers or weapons. This was a revolutionary concept in a legal world that usually treated children as property to be divided. Step 2 was information gathering, but with a twist. Instead of subpoenas and hidden bank accounts, Kugler mandated a full, transparent disclosure in a joint session. The goal was to create a single, shared reality of the family's finances. Historical trends show that this transparency alone reduced the time spent on a divorce by nearly 60% compared to traditional litigation. However, the legal establishment in the late 1970s did not take this lying down. This is where our story takes a darker, more litigious turn. As mediation began to gain traction in California and Georgia, state bar associations began to panic. They saw mediation as a threat to the billable hour and, more importantly, to the sanctity of the legal profession. In several key case studies from 1978 and 1979, mediators were threatened with the unauthorized practice of law. The argument was simple. How can a neutral party give information to a couple without accidentally giving legal advice? If a mediator tells Michael that he might have to pay a certain amount in child support based on state guidelines, is that mediator acting as a lawyer? The American Bar Association's early stance was incredibly restrictive. They effectively tried to build a wall around the mediation movement, fearing that it would lead to a Wild West, where couples made deals that were legally unsound or fundamentally unfair to the lower-earning spouse. Despite this resistance, the demand from the public was overwhelming. By 1980, the psychological community had joined the fray. Psychologists like Joan Kelly and Judith Wallerstein were beginning to publish long-term studies on the effects of divorce on children. Their data was a wake-up call for the American public. They found that the primary factor in childhood trauma following a divorce was not the separation itself, but the level of ongoing conflict between the parents. This research provided the scientific backbone that mediation needed. It wasn't just a nicer way to divorce. It was a medically and psychologically superior way to protect the next generation. This led to the birth of comprehensive mediation, where the focus shifted from purely financial settlements to parenting plans. This was the first time the term custody began to be replaced with shared responsibility in the American lexicon. As we move into the early 1980s, the movement hit a massive catalyst: the Harvard Negotiation Project. While Kugler was working in the trenches of family law, Roger Fisher and William Ury were at Harvard University developing a theory that would change global diplomacy and eventually every divorce in America. They called it principled negotiation. In 1981, they published Getting to Yes, a book that moved mediation from a fringe social movement into a mainstream professional discipline. They introduced the concept of the BATNA, the best alternative to a negotiated agreement. Imagine if Michael and Susan, now guided by these new Harvard principles in 1982, were asked to look at their BATNA. Their mediator would ask, "If you don't reach an agreement today, what is your alternative?" The answer was almost always a 2-year court battle, $50,000 in fees, and a permanent rift in the family. By framing the conflict this way, mediators weren't just being nice. They were being deeply pragmatic. They were helping couples perform a cost-benefit analysis that the adversarial system was designed to obscure. This period saw the rise of the first generation of professional mediators who were not just recovering lawyers, but were specifically trained in the art of the win-win scenario. By the mid-1980s, the historical trends were undeniable. Mediation was no longer just for the wealthy or the highly educated. It was becoming a tool for the masses. In 1984, California became the first state to mandate mediation for any couple with a custody dispute. This was a watershed moment. It signaled that the government had finally admitted that the courtroom was the worst possible place to decide the future of a child. But this sudden explosion of mediation created its own set of problems. How do you regulate thousands of new mediators? How do you ensure that a neutral mediator isn't being manipulated by a dominant spouse? And what happens when the power balance in the room is fundamentally broken by a history of domestic abuse? These were the questions that would define the next decade of conflict resolution. The transition from a fringe movement to a state-mandated requirement meant that mediation had to grow up fast. It had to develop ethics, standards, and specialized techniques for high-conflict personalities. We are talking about a shift from a feel-good alternative to a rigorous, data-driven professional field that by 2026 has become the default setting for family law across the United States. But before mediation could become the polished, professionalized system we see today, it had to survive a period of intense internal debate and external attack. In the next part, we are going to dive into the shadow of the law, a fascinating era where mediators and lawyers fought for control over the room. We will look at how the 1990s introduced the concept of evaluative mediation versus facilitative mediation, and how a single Supreme Court-level debate almost shut down the entire industry. You might think mediation is just about sitting in a circle and talking, but as we are about to see, the fight for the middle ground was anything but peaceful. Prepare yourself for the era of the power imbalance, where the history of mediation took its most controversial and high-stakes turn. As we enter the 1990s, the idealistic glow of the early mediation movement began to face a harsh reality check. This was the era where the academic world collided with the practical world of the family court. To understand this tension, we have to look at a concept known as bargaining in the shadow of the law. This term, coined by legal scholars Robert Nukin and Louis Kornhauser, suggests that what happens at a mediation table is never truly independent of what would happen in a courtroom. Imagine a couple in 1992, let us call them David and Sarah, sitting in a small windowless office in Chicago. Sarah wants to keep the family home because she has been the primary caregiver for their 3 children. David wants to sell the house to liquidate the equity. In a vacuum, they might find a compromise. But David's lawyer has told him that, based on current Illinois judicial trends, a judge would likely order the sale of the house. This knowledge follows David into the mediation room like a ghost. He is no longer negotiating based on Sarah's needs. He is negotiating based on his legal leverage. This shadow of the law created a fundamental rift in the industry, leading to the great debate between facilitative and evaluative mediation. This was a battle for the soul of conflict resolution. Facilitative mediation, which was the gold standard from the Kugler era, insisted that the mediator should never give an opinion. The mediator was there to manage the process, not the outcome. They were a guide, a mirror, and a translator. However, a new breed of mediators, often retired judges or seasoned litigators, began practicing evaluative mediation. In this model, the mediator would look at David and Sarah and say, "David, you are being unrealistic. A judge in this county will never grant that motion," or "Sarah, the law says this asset is separate property, so you should stop asking for a share of it." Historical trends show that while evaluative mediation was often faster, it risked turning the mediation room back into a mini courtroom, stripping the couple of their agency. By 1991, this tension reached a boiling point with the publication of a landmark law review article by Professor Trina Grillo titled "The Mediation Alternative: Process Dangers for Women." This paper sent shockwaves through the legal and psychological communities. Grillo argued that the very thing that made mediation attractive, its informality and focus on emotion, made it dangerous for the person with less power in the relationship. Imagine Sarah again. If David had spent years exercising financial or emotional control over her, a neutral mediator who simply encouraged them to talk it out might inadvertently allow David to steamroll Sarah into an unfair agreement. Grillo's critique suggested that the mandatory mediation laws of the 1980s were forcing vulnerable people into a room where they were expected to be their own advocates against a dominant partner. This critique forced the entire industry to pivot. It was no longer enough for a mediator to be neutral. They had to be aware of power imbalances. This led to the development of sophisticated screening protocols that are still the gold standard in 2026. Step by step, the mediation process was redesigned to include a pre-session assessment. Mediators began meeting with parties individually to ask specific, calibrated questions about domestic violence, intimidation, and financial transparency. If a significant power imbalance was detected, the mediation was either terminated or conducted through shuttle diplomacy, where the parties remained in separate rooms and the mediator moved between them. Case studies from the mid-1990s indicate that these screening tools were not just administrative hurdles. They were life-saving interventions that prevented the legal system from being used as a tool of further abuse. As the industry grappled with these ethical dilemmas, the 1990s also saw the introduction of the Uniform Mediation Act. This was a massive effort to harmonize the laws across different states. Up until this point, a mediation session in New York might have different confidentiality rules than a session in Texas. This created a legal minefield. If David admitted to hiding assets during a mediation session in one state, could Sarah use that admission against him in court if the mediation failed? The Uniform Mediation Act established a bedrock principle: mediation is a privileged communication. Just like a conversation with a priest or a doctor, what is said in the room stays in the room. This privilege was essential to the potential outcomes of the process. It allowed people to be vulnerable and honest without the fear that their words would be weaponized in a future trial. By the time we reached the late 1990s, the United States was seeing a massive diversification in how mediation was applied. We saw the rise of community-based mediation centers that offered services on a sliding scale, ensuring that the benefits of conflict resolution weren't restricted to those who could afford a private professional. This was the era of the multi-door courthouse, a concept popularized by Frank Sander, which suggested that when a person walks into a courthouse, a clerk should guide them to the door that best fits their problem, be it litigation, arbitration, or mediation. Let us look at how this evolved into the early 2000s and eventually into our current context in 2026. We began to see the professionalization of the divorce financial analyst. This was a new role created to support the mediation process. While the mediator handled the communication and the lawyers handled the statutes, the financial analyst looked at the long-term impact of the settlement. They used data to project how a 50-50 split would look 10 years down the line, considering inflation, tax implications, and college tuition. This took the guesswork out of the negotiation. It transformed mediation from a split-the-baby approach into a precise, surgical restructuring of the family's economic future. The historical trends of this period show a clear trajectory. Mediation was moving from the fringe to the foundation. In 2026, we look back at the 1990s as the decade where mediation grew up. It faced its critics, it established its ethics, and it proved that it could handle the most complex and sensitive human dramas. However, as the process became more regulated and more legalistic, some argued that it was losing its original heart. The facilitative purists worried that the spirit of the Kugler method was being buried under a mountain of paperwork and evaluative pressure. This leads us to a fascinating question that we will explore in the next part. As mediation became a billion-dollar industry and a mandatory part of the American legal system, did it actually solve the problem of conflict, or did it just move the fight from the courtroom to the boardroom? We are going to look at the rise of the super mediators, professionals who charge thousands of dollars an hour to settle high-stakes celebrity and corporate divorces. We will also examine the collaborative law movement, a radical offshoot of mediation that emerged in the late 90s, where lawyers actually sign a contract promising to quit if the case goes to court. But there is a dark side to this professionalization that we haven't touched on yet. What happens when the system becomes so efficient that it ignores the human need for justice? Is a settled case always a successful case? In the next part, we dive into the settlement trap and the rise of the collaborative law movement, where we will see how the 21st century redefined what it means to win a divorce. If you thought mediation was the final evolution of family law, you haven't seen the collaborative revolution yet. Stay with us as we uncover how a group of frustrated lawyers decided to fire themselves from the courtroom forever. The year was 1990. And a veteran family law attorney in Minneapolis named Stuart Webb was reaching a breaking point. After decades of practicing in the traditional adversarial system, Webb realized that he was no longer a healer or a counselor. He was a gladiator in a suit, participating in a system that often left both sides bankrupt and bitter. He famously decided that he would simply stop going to court. He didn't want to retire. He wanted to practice law in a way that didn't destroy the people he was representing. This was the spark for the collaborative law movement, a radical evolution that took the core principles of mediation and added a high-stakes legal framework that would change the potential outcomes for American families forever. To understand why this matters in 2026, we have to look at the psychological engine that drives this process, the disqualification clause. Imagine a couple in the present day. Let us call them Marcus and Elena. Marcus is a software engineer and Elena is a pediatrician. They have 2 children, a house in the suburbs, and a complex web of retirement accounts and stock options. In a traditional mediation, they might sit with a neutral third party to find a middle ground. But Marcus and Elena are nervous. They feel they each need a lawyer in their corner to ensure their interests are protected. In the collaborative law model, they both hire specially trained collaborative attorneys. However, before the first meeting begins, everyone, Marcus, Elena, and both of their lawyers, signs a participation agreement. This document contains a clause that seems counterintuitive at first. If the process breaks down and either party decides to go to court to let a judge decide, both lawyers are immediately fired. They are legally disqualified from representing Marcus and Elena in a contested trial. Think about the profound shift in incentives this creates. In the traditional model, a lawyer might actually benefit financially from a case going to trial. More hours billed, more motions filed, more conflict. In the collaborative model, the lawyer's entire professional stake is tied to reaching an agreement. If the negotiation fails, the lawyer loses the client. This historical trend represented a massive departure from the billable hour incentives that had governed the United States legal system for a century. It created a container where the only way out was through cooperation. For Marcus and Elena, this meant that their lawyers were no longer looking for ways to win a point at the expense of the other. They were looking for ways to solve the puzzle of the family's future. But the collaborative revolution didn't stop with lawyers. By the early 2000s, this model evolved into what we now call the interdisciplinary team approach. This is where we see the most significant data points regarding long-term family stability. Instead of just two lawyers and a couple, the room expanded to include neutral professionals. Imagine if Marcus and Elena also had a neutral financial professional and a child specialist in the room. The financial professional doesn't represent Marcus or Elena. They represent the math. They sit down with the couple's tax returns, bank statements, and mortgage details to create a clear, unbiased picture of the family's economic reality. Case studies from this era suggest that using a single neutral financial expert can reduce the total cost of asset division by up to 40% compared to each side hiring their own forensic accountant to argue over the value of a business. Then there is the child specialist, usually a mental health professional with deep expertise in child development. In the traditional adversarial system, children were often the silent victims or, worse, the objects of a custody battle. In the collaborative model, the child specialist meets with the children privately to understand their needs, fears, and hopes. They then bring the voice of the child back to the parents in the negotiation room. This is a critical distinction. It is not about what the child wants, which can be a heavy burden for a child to carry, but about what the child needs. Step by step, the child specialist helps Marcus and Elena build a parenting plan based on developmental stages rather than legal precedents. Historical trends show that parenting plans created this way have a much higher rate of compliance and a lower rate of future litigation. As this movement gained steam throughout the 2010s and into the early 2020s, it began to address the settlement trap that had plagued early mediation. The settlement trap occurs when one party, exhausted by the process or intimidated by the other, agrees to terms that are fundamentally unsustainable just to end the conflict. Because collaborative law involves partisan attorneys who are present during every negotiation, there is a built-in safeguard against the power imbalances that Trina Grillo warned about in the 1990s. Elena's lawyer is there to ensure she isn't bullied into a bad financial deal, while Marcus's lawyer ensures he isn't being cut out of his children's lives. It is a balanced, four-way conversation where the focus is on interest-based negotiation rather than positional bargaining. However, this level of depth and professional involvement comes with a price tag. Critics of the collaborative movement often pointed out that while it was cheaper than a 3-year court battle, it was still significantly more expensive than simple mediation. This led to a bifurcated market in the United States conflict resolution landscape. On one hand, you had pro se mediation for couples with few assets and low conflict. On the other, you had the high net worth collaborative model for families with complex estates. By 2026, we see that the market has responded with modest means collaborative programs, which use junior professionals and fixed fee structures to bring this team-based approach to the middle class. Let us look at a specific case study involving a family business, a common point of failure in traditional divorces. Imagine a couple that owns a successful chain of coffee shops. In a courtroom, the business might be ordered to be sold or one spouse might be ordered to buy out the other, potentially crippling the company's cash flow. In a collaborative setting, the team can work with a business valuator to create a creative structured buyout over 10 years, or even a transition plan where both parties remain shareholders, but only one manages the day-to-day operations. This level of creativity is virtually impossible in a courtroom, where a judge is bound by narrow statutes and limited time. The potential outcomes here aren't just about the divorce. They are about the survival of an American small business. The impact of this revolution extended beyond the clients to the professionals themselves. We began to see the rise of the peacemaker identity among lawyers. Law schools started offering courses not just on litigation, but on collaborative practice. The historical trend was clear. The legal profession was slowly acknowledging that its role in family law was changing from that of a combatant to that of a transition manager. But as we mastered the art of the team-based negotiation, a new challenge was appearing on the horizon, one that would threaten the very human-centric nature of mediation and collaborative law. As we moved into the 2020s, technology began to infiltrate these private rooms. At first, it was just Zoom meetings and digital document sharing. But soon, algorithmic tools began to promise even more efficiency. We started seeing the first iterations of AI-driven settlement suggestions and automated asset division software. This brings us to a critical junction in our history. We have spent nearly a century moving from the cold, impersonal courtroom to the warm, human-centric mediation room. Now, are we about to hand the process back over to the machines? In the next part of this deep dive, we are going to explore the digital transformation of conflict resolution. We will look at how the 2020s sparked a surge in ODR online dispute resolution, and how the year 2026 has become the testing ground for AI mediators. Can an algorithm truly understand the voice of a child? Can software navigate the deep-seated emotional hurt of a 20-year marriage? Prepare to see how the collaborative revolution met the artificial intelligence explosion, and why the future of your family's privacy might be sitting in a server farm in Silicon Valley. The fight for the human element in conflict resolution is just beginning. The year 2020 acted as a violent catalyst that compressed a decade of technological evolution into a single calendar year. Before the global pandemic, the gold standard of mediation was still the physical room. The shared box of tissues, the heavy silence across a mahogany table, and the subtle nonverbal cues that a skilled mediator could detect from across the carpet. But when the world shut down, the American legal system faced a choice: freeze entirely or embrace the screen. This was the birth of the era of widespread online dispute resolution, or ODR. As we stand here in 2026, we are witnessing the full maturation of this digital transformation, where the history of mediation has moved from the physical presence of a guide to the digital presence of an algorithm. To understand where we are today, we must analyze the step-by-step progression of how conflict resolution became data-driven. Imagine a couple in 2026. Let us call them Liam and Chloe. They represent the modern American household. Liam is a remote consultant, and Chloe manages a digital marketing agency. Their entire lives are documented in the cloud: their bank statements, their shared calendars, their grocery lists, and even the sentiment of their text messages. When they decide to separate, they do not start by calling a lawyer. They start by logging into a conflict resolution platform. This is the new reality of the 2020s. The first step in their journey is no longer an orientation session with a human. It is a data ingestion phase. The platform asks for access to their financial APIs. Within seconds, years of financial history are categorized. The potential outcomes of their property division are not guessed. They are calculated based on a historical trend analysis of thousands of similar cases in their specific zip code. This historical trend of using predictive analytics began in the mid-2010s, but exploded in the early 2020s. Early case studies from Pioneer platforms showed that when parties were presented with the range of likely judicial outcomes based on hard data before the emotions of the negotiation took over, the rate of settlement increased by over 30%. For Liam and Chloe, the computer screen displays a bell curve. It shows them that in 95% of cases like theirs, the family home is sold, and the equity is split according to a specific formula that accounts for their individual contributions and future earning capacities. By seeing this data, Liam and Chloe are less likely to enter the negotiation with unrealistic anchor positions. The algorithm has already set the boundaries of the possible, but the digital transformation of 2026 goes deeper than just spreadsheets. We are now in the age of natural language processing and sentiment analysis in mediation. During their asynchronous sessions, where Liam and Chloe post their thoughts and proposals at different times rather than sitting in a live meeting, the AI mediator analyzes their tone. If Liam writes a proposal that is flagged as high conflict or passive-aggressive, the system prompts him before he hits send. It might say, "Liam, based on historical data, messages with this tone have a 60% lower chance of reaching a positive response. Would you like to rephrase this?" This is what we call nudge theory applied to family law. It is a step-by-step process of de-escalating conflict before a human mediator even enters the chat. However, the history of this digital shift is not without its controversies. As we move deeper into the 2020s, the shadow of the algorithm began to replace the shadow of the law. Critics argue that while an AI can analyze a bank statement, it cannot understand the inherent value of a family heirloom or the complex emotional history behind a specific parenting request. For example, in a 2024 case study, a digital mediation platform suggested a perfectly symmetrical 50-50 parenting schedule for a couple in Seattle. On paper, it was the most efficient and fair outcome, but the algorithm didn't account for the fact that one child had a sensory processing disorder that made frequent transitions between homes deeply traumatic. It took a human mediator, intervening after the digital process stalled, to realize that the efficient solution was a human failure. This brings us to the core tension of conflict resolution in 2026: the balance between efficiency and empathy. Historical trends indicate that as mediation became more automated, it also became more accessible. For a couple in a rural area or for those with limited financial resources, an AI-assisted mediation platform might cost $500, whereas a traditional mediated divorce could cost $5,000 or more. This democratization of conflict resolution is one of the most significant potential outcomes of the last century. It means that the peacemaking once reserved for those who could afford professional fees is now a public utility. We must also look at the rise of smart contracts in the history of 2020's mediation. By 2026, many mediated settlement agreements are no longer just PDF documents filed with a court. They are executable code. If Liam and Chloe agree that Liam will pay child support on the 1st of every month, that agreement is linked to their bank accounts. If the payment is not triggered, the system automatically notifies both parties, and in some jurisdictions, updates the court record. This reduces the need for the post-decree litigation we discussed earlier. The conflict resolution is built into the infrastructure of their lives. But as we master the what and the how of digital mediation, we are seeing a growing movement of people who are pushing back. They are calling for a return to the human element. They argue that by turning a divorce into a data optimization problem, we are stripping away the essential ritual of closure. In 1975, O.J. Kugler wanted people to talk to each other to heal. In 2026, we have people clicking buttons to settle. We have reached a point in history where we can resolve the conflict without ever truly resolving the relationship. This has led to a fascinating new trend: the rise of hybrid mediation, where AI handles the data and the math, but a human specialist is brought in specifically to handle the emotional architecture of the split. Let us analyze the step-by-step process of a 2026 hybrid session. Step 1 is the algorithmic audit, where all finances are cleared and categorized by software. Step 2 is the interest-based interface, where the parties use digital tools to rank their priorities. Step 3 is the human synthesis. This is where a professional mediator reviews the digital output and hosts a final, high-impact session, often in person or via high-definition video, to finalize the parenting plan and ensure both parties feel heard, not just calculated. As we look back over the last 100 years, from the era of proving fault in a courtroom to the era of sentiment analysis in a digital portal, the goal has remained the same: reducing the collateral damage of human conflict. But as we move forward, we face a new set of high-stakes questions. If the algorithm is doing the mediating, who is responsible when the outcome is biased? If our most private family conflicts are stored on servers, what happens when that data is breached? And most importantly, as we make the process faster and cheaper, are we accidentally making divorce too easy? Or are we finally providing a humane exit for those who need it most? The history of mediation is at a crossroads. We have perfected the mechanics of the deal, but we are still struggling with the heart of the matter. In the next part of this deep dive, we are going to look at the privacy wars. We will explore how the transition to digital mediation has created a massive new market for conflict data, and how your most intimate negotiations are becoming a valuable commodity for insurance companies and financial institutions. You thought your mediation was private because it wasn't in a courtroom, but in the digital age, is anything truly private? Prepare to look at the dark side of the digital peacemaking revolution. We are going into the server rooms of Silicon Valley to see who is really sitting at the mediation table with you. To understand the magnitude of the privacy crisis currently unfolding in 2026, we have first to look back at the original selling point of mediation in the 20th century. For decades, the primary reason an American couple chose mediation over litigation was the promise of the closed door. In a courtroom, your dirty laundry is public record. Your financial failures, your parenting lapses, and your deepest resentments are transcribed by a court reporter and filed in a government building for anyone with a search fee to see. Mediation was the antidote to this exposure. Under the Uniform Mediation Act of the early 2000s, the conversation was legally privileged. But as we moved into the digital era, we replaced the court reporter with the server, and the closed door with a user agreement. Imagine a user in 2026. Let us call him James. James is a middle manager at a logistics firm in Ohio. He is going through a divorce with his spouse, Mia. To save money, they opt for a mid-tier digital mediation platform that uses an AI facilitator. During a high-stress session late on a Tuesday night, James types a long, vulnerable message into the chat window. He admits that his recent struggle with chronic stress and burnout is the reason he is asking for a gradual step-up parenting plan, rather than immediate 50-50 custody. He feels safe because the platform's marketing materials prominently feature the word confidential. In the legal sense, James is correct. Mia's lawyer cannot use that specific chat message as an exhibit in a trial because of mediation privilege laws. However, James has forgotten that in the digital age, there is a massive difference between legal confidentiality and data privacy. As James hits send, his admission of burnout is processed by the platform's large language model. But the platform he is using is owned by a parent corporation that also manages consumer data for financial services. Step by step, James's admission begins a journey through the back end of the conflict resolution industry. The platform's terms of service, which James scrolled through and clicked accept on in 3 seconds, state that while the data is not shared with third parties for legal discovery, it can be used for internal product improvement and anonymized behavioral analysis. In the world of 2026, anonymized is a flexible term. By cross-referencing James's IP address, his device ID, and his specific linguistic patterns, data brokers can reconstruct his profile with terrifying accuracy. Historical trends show that by the mid-2020s, the monetization of conflict data became a multi-billion-dollar secondary market. 6 months after his mediation is finalized, James goes to renew his life insurance policy. He is shocked to find that his premium has increased by 35%. When he calls to inquire, he is given a vague explanation about updated risk models. What he does not know is that a data aggregator purchased a behavioral score from a consortium that includes the mediation platform he used. The score flagged him as a high risk for health-related work absences based on his self-reported burnout during his divorce. This is the potential outcome of the digital peacemaking revolution. The very room where you are supposed to be most honest becomes the place where you are most professionally and financially vulnerable. Let us analyze a specific case study from 2024 that set the stage for our current reality. A major online dispute resolution provider in the United States, which we will refer to as Resolve IT, suffered what was then called a credential stuffing attack. Over 40,000 sensitive financial disclosures, including tax returns, social security numbers, and lists of private assets, were exfiltrated and sold on the dark web. In a traditional divorce, these documents would have been in a physical file or a highly secure government database. In the mediation world, they were sitting on a relatively low-security startup server. The fallout was catastrophic. Because these were private mediation files, many of the victims didn't even know their data was at risk until their identities were stolen months later. This event sparked the first major wave of 2026 legislation, aimed at creating a digital mediation bill of rights. This brings us to the current battle in the United States Congress, the struggle over the privacy paradox. On one hand, we want mediation to be accessible, cheap, and data-driven because it saves families from of court. On the other hand, the data required to make these systems efficient is the most sensitive data a human being can produce. To solve this, a new movement of privacy-first mediators has emerged in 2026. They are using technologies like zero-knowledge encryption, where the mediation platform facilitates the conversation but never actually sees the content of the messages. Imagine a system where the AI can help you negotiate, but the moment the session ends, the key to that data is destroyed, leaving no trace for data brokers to harvest. But these high-security options come with a premium price tag, creating a two-tiered system of justice. If you are wealthy, you can afford a mediator who uses a secure, offline, air-gapped environment. If you are a person of modest means, you are forced to use the free or low-cost apps that trade your privacy for their services. This is a radical departure from the egalitarian goals of the 1970s pioneers. We have moved from a system where everyone was equally protected by the law to a system where your level of privacy is determined by your subscription tier. Step by step, the industry is now trying to retroactively fix these holes. We are seeing the rise of the mediation data auditor, a professional whose job is not to resolve the divorce, but to ensure that the digital footprint of the divorce is erased once the final decree is signed. This includes cleaning up shared cloud drives, removing access to synchronized calendars, and ensuring that the AI models used during the sessions do not retain the family's specific data for future training. This is a complex, technical process that involves scrubbing metadata from thousands of shared photos and documents that were used as evidence during the asset division phase. The potential outcomes of this privacy war will define the next century of conflict resolution. If we fail to secure the mediation room, we risk driving people back into the adversarial court system, not because they want to fight, but because they trust the government's clunky public security more than Silicon Valley's slick private vulnerability. We are at a point where the history of mediation is looping back on itself. The very transparency that helped Liam and Chloe reach a settlement in our previous example is now the very thing that could haunt them for the rest of their lives. As we look toward the final parts of this masterclass, we have to ask ourselves, is the trade-off worth it? We have successfully reduced the cost of divorce. We have reduced the time spent in conflict. We have used data to create fairer outcomes for children. But in doing so, have we turned the American family into a data set to be optimized and sold? In the next part, we are going to look at the global impact, how the United States model of mediation has been exported to the rest of the world, and how different cultures are reacting to the digital peacemaking machine. We will look at how countries in Europe and Asia are handling the privacy crisis differently, and what the US can learn from their more stringent data protections. But there is one more twist in the domestic story. While we have been focusing on the digital and the legal, a new grassroots movement is growing in the heart of America. The return to the kitchen table mediation. A group of professionals is intentionally ditching the tech and going back to the basics. Why is this happening now, in the most technologically advanced era of human history? The answer lies in the one thing an algorithm can never truly provide: human witness. Prepare for a deep dive into the neo-traditionalist movement in mediation, where the most high-tech families in the world are paying thousands of dollars just to sit in a room with a human being who has no laptop, no phone, and no record. The future of mediation might just look a lot like the past, and you won't believe what these analog sessions are uncovering. By the year 2026, the pendulum of conflict resolution in the United States has swung back with a force that few technologists predicted. We call this the neo-traditionalist movement, and it is the direct response to the digital exhaustion and privacy anxiety that defined the early 2020s. To understand why some of the most powerful people in America are now paying upwards of $10,000 a day to sit in a room with no electronics, we have to explore the psychological concept of the human witness. This is a term that historical trends have shown to be the missing ingredient in the era of algorithmic settlements. In the 1970s, O.J. Kugler and the other pioneers of mediation believed that the presence of a neutral human could de-escalate the biological fight-or-flight response. In 2026, we are finding out that they were more right than they ever could have imagined. Imagine a case study involving a couple we will call Robert and Sarah. Robert is a high-ranking executive at a major social media conglomerate, and Sarah is a renowned surgeon. They are the ultimate power couple of 2026, and their divorce involves assets spread across 3 continents and 4 different asset classes. They have spent months using the highest-tier AI mediation platforms, but the process has stalled. The algorithm has calculated the math perfectly, yet neither of them will sign the final decree. Why? Because the algorithm cannot account for the fact that Robert feels Sarah never respected his career sacrifices, and Sarah feels Robert was emotionally absent during the birth of their second child. These are not legal or financial problems, they are human grievances. Robert and Sarah decide to hire a neo-traditionalist mediator. This is a professional who operates in what the industry now calls a black box environment. Step by step, the process is a radical departure from the digital status quo. When they arrive at the mediator's office, usually located in a neutral, tranquil space like a quiet colonial in Virginia or a ranch in Ohio, the first thing they do is the device deposit. All smartphones, tablets, and even smartwatches are placed in a lead line box at the door. There are no cameras, no microphones, and most importantly, no record. The mediator uses a physical whiteboard and yellow legal pads. Historical trends suggest that this lack of a digital footprint allows for a level of raw, unfiltered honesty that is impossible when you know your words are being processed by a server. In this analog environment, the mediator utilizes a technique known as the table ritual. This is a structured approach designed to re-engage the mirror neurons in the human brain. When Robert and Sarah are in the same physical space, breathing the same air and seeing the subtle micro-expressions on each other's faces, their brain chemistry begins to shift. Data from 2025 neurological studies indicates that physical proximity and high-stakes negotiation can lower cortisol levels by as much as 30% compared to video conferencing. The mediator does not start with the bank accounts. They start with the human narrative. Each party is given 30 minutes of uninterrupted time to tell their story, not as a legal argument, but as a personal history. During these sessions, the analog mediator is looking for what we call the core conflict driver. This is the underlying emotional wound that prevents a legal settlement. In Robert and Sarah's case, the mediator uncovers something the AI missed entirely. The dispute over a specific vacation home in Aspen wasn't about the equity. It was about the fact that it was the only place where Robert felt he truly had Sarah's undivided attention. Once this was witnessed by Sarah in the presence of a neutral human, the legal logjam broke. This is the power of the human witness. A person who can look you in the eye and say, "I hear how much that hurt you," provides a form of psychological closure that no amount of data optimization can replicate. The step-by-step progression of a 2026 analog session often includes a phase called scribing. Instead of a computer generating a contract, the mediator and the couple participate in the physical act of writing out their agreement by hand on large sheets of paper. This is not just a stylistic choice. It is a cognitive one. Evolutionary psychology suggests that the slower pace of handwriting allows the prefrontal cortex to remain in control, preventing the emotional centers of the brain from hijacking the negotiation. Potential outcomes of this slow mediation model include a much higher degree of settler satisfaction. When you have physically written the terms of your future, you feel a level of ownership that a digital click to accept cannot provide. Historical trends in the mid-2020s show a massive socio-economic divide forming around this concept. While the masses are directed toward the efficiency of ODR and AI, the elite are opting for these analog, human-centric retreats. This has created a new class of master mediators, who are less like lawyers and more like modern-day secular priests. They are trained in everything from family systems theory to somatic experiencing. They understand that a divorce settlement is a ritual of transition. If you skip the ritual, the transition never truly ends, leading to years of lingering resentment and shadow conflict. But what are these analog sessions uncovering that the digital ones are not? The answer lies in the nuance of interest-based negotiation that Fisher and Urey pioneered in 1981, but taken to its extreme. We are discovering that in the absence of digital distraction, couples are more likely to reach integrative solutions that are objectively better for the children. For example, a 2026 case study of an analog mediation in Austin, Texas, resulted in a parenting plan that included a nesting arrangement where the children stayed in the family home and the parents moved in and out. The AI had flagged this as inefficient and high risk, but the human mediator saw that both parents were committed to the children's stability above their own convenience. As we look at the potential outcomes of this neo-traditionalist movement, we see a surprising result. These families often emerge from the process with a functioning co-parenting relationship, whereas those who use purely digital means often remain digitally distant, but emotionally volatile. The analog movement has proven that conflict resolution is not just about the division of things. It is about the transformation of the relationship from married to co-parents. By 2026, the history of mediation has come full circle. We tried to make it a science, but we found out it will always be an art. However, the luxury of the analog session is not available to everyone. This brings us to a critical junction in the American story of conflict resolution. How do we bring the human back to the digital? How do we ensure that a family in a rural town using a smartphone app gets the same level of emotional closure as a billionaire in a black box room? This is the great challenge of the next decade. We are seeing the first attempts at empathy-augmented AI, but the results are mixed. Can you program a machine to be a witness? As we move into the final parts of this deep dive, we are going to look at the global export of the American mediation model. The US has spent 50 years refining these techniques, and now they are being used to settle international disputes and corporate wars in every corner of the globe. But there is a massive cultural clash brewing. In many cultures, the American idea of direct communication and neutrality is seen as a weakness or a violation of tradition. We are going to see how the Western peace is being challenged by ancient methods of resolution in the East. And finally, we will ask the most important question of all. After a century of conflict resolution, is the American family actually any happier? Or have we just become better at being apart? Prepare for a look at the Global Peace Index and how your private divorce might be the key to preventing the next world war. The connection between the kitchen table and the United Nations is closer than you think. To understand how a domestic dispute in a Denver suburb can influence a diplomatic negotiation in Geneva, we have to look at the historical trend of the professionalization of peace. In the late 1990s and early 2000s, the techniques developed in the pressure cooker of American family law began to leak into the world of international diplomacy. This was the era where Track 2 diplomacy, informal, non-governmental conflict resolution, began to borrow heavily from the interest-based negotiation models of the Harvard Negotiation Project. By 2026, this cross-pollination has reached its peak. We are seeing a generation of diplomats who were trained not in classical political science, but in the same somatic experiencing and facilitative mediation techniques used by the neo-traditionalists we discussed in the previous part. The primary export of the United States in this field is the concept of the low-context, interest-based settlement. In the US, we value transparency and directness. We want to get to the bottom line. This model was formally codified for the global stage with the Singapore Convention on Mediation, which came into full international force in the early 2020s and has reached massive scale by 2026. This convention did for mediation what the New York Convention did for arbitration. It allowed mediated settlement agreements to be enforced across international borders without having to litigate the entire case from scratch. This was a game changer for the global family. Imagine a case study involving a couple in 2026, whom we will call Sophia and Hiroshi. Sophia is an American architect living in New York, and Hiroshi is a Japanese tech executive based in Tokyo. They met in London, married in France, and have children with dual citizenship. Assets include a vineyard in Italy and a sprawling digital estate of cryptocurrency and intellectual property. In the 1980s, their divorce would have triggered a decades-long legal war involving the Hague Convention on the civil aspects of international child abduction and conflicting jurisdictions that could never agree on which law applied. The potential outcomes would have been a fragmented family where one parent is effectively exiled from the children's lives. But in 2026, Sophia and Hiroshi enter the Global Mediation Protocol. This is a step-by-step framework that utilizes the Singapore Convention to ensure that whatever they agree on in a neutral city like Singapore or Zurich is legally binding in both the United States and Japan. However, this is where we encounter the great cultural clash of the 21st century. The American model of mediation assumes that the mediator should be a neutral stranger with no connection to the parties. In many Eastern cultures, including Hiroshi's, the idea of a stranger mediating a family matter is seen as shameful and ineffective. Traditionally, conflict was resolved by a respected elder or a mutual family friend, someone who is decidedly not neutral, but rather deeply invested in the outcome for the sake of social harmony. This friction has led to the rise of the hybrid culture mediator in 2026. These are professionals who practice what is known as culturally sensitive shuttle diplomacy. Step by step, the mediator facilitates the American need for legal precision and individual rights with the Japanese need for face-saving and collective stability. In Sophia and Hiroshi's case, the mediator had to navigate the fact that Hiroshi's communication style was high context. He would not say "I disagree." He would say "that is very difficult." To an American mediator, that sounds like an opening for negotiation. To Hiroshi, it was a hard no. The success of their mediation depended on the mediator's ability to act as a cultural translator, moving beyond the words to the underlying cultural intent. This leads us to the micro-to-macro theory of peace, which is a cornerstone of conflict resolution study in 2026. The theory posits that the way a society handles its smallest units of conflict, the family, dictates how it handles its largest units of conflict, the state. If a nation's legal system is purely adversarial, rewarding those who can most effectively destroy their opponent in a divorce, that nation will naturally lean toward an adversarial foreign policy. Conversely, the rise of mediation in the United States over the last century has coincided with a shift toward soft power and multilateralism in global affairs. We are seeing data in 2026 that shows a correlation between the number of mediated settlements in a country and that country's score on the Global Peace Index. When a population learns the skills of interest-based negotiation at the kitchen table, they demand those same skills from their leaders at the United Nations. But we must also analyze the potential outcomes of this global standardization. Critics argue that by exporting the American mediation model, we are engaging in a form of legal imperialism. We are forcing a Western individualistic framework onto cultures that have successfully resolved conflict through communal and religious means for thousands of years. In 2026, we are seeing a pushback in parts of the Global South, where community leaders are reclaiming their traditional roles in conflict resolution, rejecting the slick, corporate-style mediation platforms of Silicon Valley. They argue that the American model is too focused on the transaction and not enough on the reconciliation. Let us look at a specific case study from 2025 regarding the peacemaker identity in international corporate mergers. When two massive firms, one from the US and one from Germany, merged to create a dominant player in renewable energy, the process nearly collapsed due to a cultural misunderstanding of authority. The American executives wanted a flat, mediated structure, The German executives wanted a clear hierarchy. The team brought in a family mediator who specialized in high-conflict sibling dynamics within family-owned businesses. By treating the two corporations like siblings fighting over an inheritance, the mediator was able to use family systems theory to identify the power imbalances that were stalling the merger. This is the ultimate evolution of the field. The tools of divorce are now the tools of global commerce. However, as we move into 2026, we are facing a new and unexpected challenge. We have become so good at resolving the visible conflict, the assets, the schedules, the legal terms, that we are ignoring what psychologists are calling the shadow conflict. This is the conflict that remains after the mediation agreement is signed. Historical trends show that while mediation settlements have high rates of compliance, they do not always lead to psychological peace. In fact, some data suggest that the efficiency of modern mediation may actually suppress the healthy expression of grief and anger, leading to a phenomenon known as the delayed reaction divorce, where the parties remain legally settled but emotionally at war for decades. This brings us to the most difficult question of this entire masterclass. After a century of innovating, after moving from the courtroom to the boardroom to the server room, and finally to the analog retreat, have we actually made the American family any happier? Or have we just become more efficient at being unhappy together or apart? We have mastered the art of the settlement, but have we lost the art of the relationship? In the next part, we are going to dive into the happiness paradox. We will analyze the longitudinal data from 1926 to 2026 to see if the reduction in legal conflict has actually translated to an increase in human flourishing. We are going to look at the rise of the post-mediation specialist, a new profession dedicated to what happens in year 2, year 5, and year 10 after the divorce is finalized. And finally, we will explore the controversial recoupling movement, where mediation is being used not to end marriages, but to radically restructure them so they don't have to end. You've seen the history of how we pull things apart. Now prepare for the future of how we might actually keep them together. We are entering the era of the marital remediation, and the rules of the game are about to change once again. The shift we are witnessing in 2026 is perhaps the most ironic turn in the century-long history of American conflict resolution. For 99 years, mediation was the tool you used to dismantle a life. It was the sophisticated, humane way to say goodbye. But as the data from 100 years of divorce began to pile up, researchers and practitioners noticed a startling historical trend. Many of the couples who successfully navigated a mediated divorce reported that the communication skills they learned during the process were the very skills that might have saved their marriage if they had applied them 5 years earlier. This realization has birthed the marital mediation movement, also known as mediation to stay married. Instead of using a neutral third party to negotiate an exit, couples are now using mediators to negotiate a new set of operating instructions for their continued partnership. To understand the depth of this shift, we must analyze the longitudinal data concerning the happiness paradox. If you look at the United States in 1926, the social pressure to remain married was absolute, but the internal conflict was often repressed, leading to a quiet, lifelong resentment. By 1976, the pendulum had swung toward liberation through litigation. Yet the emotional cost remained devastating. By 2026, we have perfected the art of the clean break. But the data suggests that the clean break does not always lead to a more fulfilled life. A major 2025 study from the University of Chicago followed 5,000 individuals who utilized different conflict resolution methods. The potential outcomes showed that those who engaged in high-conflict litigation had the lowest long-term life satisfaction, which was expected. However, the surprise was that those who utilized efficient, purely digital mediation also reported a sense of emotional incompleteness. They had resolved their assets, but they had not resolved their patterns. This is where Nathan and Emily come in. It is 2026, and they have been married for 12 years. They have 2 children, a joint mortgage in Austin, and a recurring argument about career prioritization that has escalated into a Cold War. In 1996, they might have gone to a marriage counselor to talk about their feelings. In 2006, they might have toughed it out for the kids. In 2026, they hire a marital mediator. This is a crucial distinction. Therapy often looks backward at the roots of behavior. Mediation looks forward at the structure of the agreement. Nathan and Emily are not there to fix their past. They are there to draft a marital operating agreement. Step by step, the marital mediation process mirrors the divorce process but with a completely different objective. Step 1 is the pain point identification. The mediator helps Nathan and Emily move beyond general complaints like "you never help me" and into specific, interest-based needs. Nathan needs 2 nights a week of uninterrupted deep work time for his startup. Emily needs a dedicated financial budget for her parents' elder care that does not require a weekly debate. Historical trends in this new field show that nearly 70% of marital conflict stems from unstated expectations regarding time and money. By treating these as negotiable line items rather than moral failings, the mediator de-escalates the emotional charge. Step 2 is the postnuptial restructuring. This is a high-stakes legal and financial component that distinguishes marital mediation from traditional counseling. In 2026, it is common for couples to use mediation to draft or amend a postnuptial agreement that addresses the very issues causing their friction. If Emily feels financially vulnerable because she took a career hit to raise the children, the agreement might stipulate a specific allocation of marital assets to her personal accounts now, rather than waiting for a potential divorce. This provides her with the psychological safety necessary to stay in the relationship. It is an investment in the marriage through the clarity of the potential outcomes of a separation. As we analyze this trend, we see that the history of mediation is moving toward a preventative maintenance model. We are seeing the rise of the post-mediation specialist, a role that did not exist 10 years ago. These professionals are hired on an annual retainer by families to facilitate quarterly check-ins. Imagine it like a board of directors meeting for your family. They review the parenting plan, the household budget, and the communication goals. They look at the data of the previous 90 days. Did we stick to our agreed-upon screen time limits for the kids? Did we hit our savings goals for the summer house? By bringing the rigor of conflict resolution into the daily life of a healthy marriage, these specialists are effectively engineering a reduction in future divorce rates. But let us look deeper into the data of why this is happening now. In 2026, the American public has a more transactional view of relationships than previous generations. This is not necessarily a negative shift. It is a move toward radical transparency. People are no longer content with the vague promise of for better or for worse. They want to define exactly what better looks like. Case studies of marital mediation show that when the rules of a relationship are co-created and clearly documented, the cognitive load of the marriage decreases. There is less to guess about, which means there is less to fight about. This brings us to the ultimate question of the happiness paradox. Can you negotiate your way into love? The critics of the marital mediation movement argue that by turning a marriage into a series of mediated agreements, we are stripping away the spontaneous, sacrificial nature of love. They worry that we are creating a society of roommates who are only together because the contract is favorable. However, proponents point to the historical trends of the early 20th century, where lack of clarity and power imbalances led to widespread domestic misery. They argue that a marriage built on a foundation of fair, mediated agreements is actually more romantic because it allows the parties to focus on each other rather than on the logistics of survival. The potential outcomes of this shift are profound. If marital mediation becomes the standard in the United States, we may see a stabilization of the family unit that hasn't been seen since the pre-divorce era, but this time it will be based on choice rather than coercion. We are seeing 2026 data that suggests children raised in homes that utilize professional conflict resolution techniques, even for minor disputes, develop higher levels of emotional intelligence, and are more successful in their own future relationships. The mediation table is becoming the new classroom for the next generation of American citizens. But as we master the art of keeping things together, we are facing one final massive hurdle. We have looked at the law, the tech, the privacy, the global export, and the marital restructuring. But what happens when the conflict is not between a couple, but between a person and the system itself? As we move into the final part of this masterclass, we are going to explore the future of public interest mediation. We will look at how these same techniques are being used to resolve massive social and political divides in the United States. We are going to see if the lessons learned from a century of divorce can be used to prevent a civil war. Prepare for the ultimate deep dive into the 2026 Great Reconciliation. We are going to look at how mediators are being deployed into city councils, corporate boardrooms, and even the halls of Congress to apply the Kugler method to the national identity crisis. Can a country that has learned how to divorce with dignity finally learn how to live together with respect? The final chapter of our century of conflict resolution is not about the end of a marriage. It is about the birth of a new kind of social contract. This is the part where the history of your family meets the history of your country. Don't miss the conclusion to the most important story of the last 100 years. We are standing at the threshold of a new era in the United States, one where the hard-won lessons of the mediation table are being applied to the very fabric of our national identity. As we navigate the year 2026, the historical trends we have tracked, from the wood-paneled courtrooms of the 1920s to the algorithmic interfaces of the early 2020s, have converged into a singular realization. Conflict is not an obstacle to be removed, but a resource to be managed. This is the birth of the Great Reconciliation, a movement where the techniques developed to save families from the trauma of divorce are now being deployed to save communities from the trauma of polarization. To understand this final evolution, we must look at how the role of the mediator has transformed from a legal neutral into a civic architect. Imagine a citizen named Jordan in a mid-sized American city in 2026. Jordan is attending a town hall meeting regarding a highly controversial urban redevelopment project that threatens to displace long-term residents while promising economic revitalization. In 2016, this meeting would have been a theater of shouting matches, protest signs, and a binary choice between two extreme positions. But in 2026, the city has appointed a resolution architect. This professional does not start the meeting with a presentation of facts and figures. Instead, they begin with a process called stakeholder mapping, a technique borrowed directly from high-stakes multi-party family mediation. Step by step, the resolution architect guides the community through the identification of shared interests. Just as a mediator helps a divorcing couple realize that their shared love for their children is more important than their hatred for each other, the architect helps the developers and the residents realize they both share an interest in safety, property value, and community legacy. This is not about compromise, which often leaves everyone feeling like they have lost. This is about integration. Case studies from 2025 in cities like Denver and Charlotte show that when civic disputes are mediated rather than litigated or protested, the resulting policies have a 75% higher rate of public approval and a significantly lower rate of legal challenge. This brings us to the core of the new social contract of 2026. We are witnessing the end of the age of the adversary. For a century, the American legal and political systems were built on the belief that the truth emerges from a clash of opposites: prosecution versus defense, Republican versus Democrat, plaintiff versus respondent. But as we have seen in the history of divorce, the adversarial model often produces a winner and a loser, but it rarely produces peace. The potential outcomes of a century of winners and losers have been a society that is legally settled but emotionally fractured. The new social contract replaces the clash of opposites with the synthesis of interests. Let us analyze the data behind this shift. In 2026, over 40% of United States law schools have rebranded their litigation departments as departments of dispute resolution. This historical trend is a direct result of the market demand for peacemakers. The cost of conflict in the U.S., measured in legal fees, lost productivity, and the healthcare costs associated with chronic stress, was estimated in 2024 to be nearly $2 trillion annually. By 2026, the federal government has introduced the National Resolution Act, which provides tax incentives for corporations and municipalities that utilize certified mediation processes before engaging in formal litigation. This is the macro application of the Kugler method, moving the focus of the entire nation from the fault to the future. But how does this affect you, the individual standing in 2026? It means that the skills of conflict resolution are no longer specialized tools for lawyers. They are essential life skills for every citizen. We see this in the 2026 educational curriculum, where conflict literacy is now a required subject in public high schools across 32 states. Students are taught how to differentiate between a position and a need. They learn the art of active listening and the science of the I statement. Imagine a generation of Americans who enter adulthood knowing that being right is often the most expensive and least productive outcome of any disagreement. This is the ultimate potential outcome of the mediation movement, a population that is psychologically inoculated against the toxicity of binary conflict. However, the history of this century has also taught us a vital lesson about the settlement trap on a national scale. We must be careful that in our pursuit of reconciliation, we do not suppress the necessary and healthy expressions of justice. A settled case is not always a just case. This is why the 2026 model of public interest mediation includes a justice audit. Before any mediated agreement, whether it is a divorce or a national policy, is finalized, it is reviewed by a neutral panel to ensure that it does not reinforce systemic power imbalances. We are learning that peace without equity is merely a temporary truce. As we look back at the last 100 years, the The journey of divorce mediation serves as a perfect mirror for the journey of the American spirit. We began with a rigid, moralistic system that used the law to punish and control. We moved into a period of chaotic liberation where we broke the old structures but struggled to build new ones. We went through a period of technological obsession where we thought algorithms could solve our human problems. And finally, we have arrived at a place of sophisticated humanism. We have realized that the most powerful technology we possess is the ability to sit across from someone we disagree with and say, "Tell me more so that I can understand." The history of divorce mediation is the history of America learning how to grow up. It is the story of a culture moving from the impulsive fight or flight of the courtroom to the deliberate, adult conversation of the mediation room. By 2026, we have proven that we can dismantle a marriage with dignity. Now, we are proving that we can rebuild a society with respect. The tools are in our hands. The yellow legal pads, the whiteboard, the device-free rooms, and the interest-based questions are not just for people who are parting ways. They are for all of us who are trying to find a way forward together. As we conclude this deep dive masterclass, we must acknowledge that the story is far from over. The next century of conflict resolution will likely be defined by challenges we cannot yet imagine. Conflicts over digital sovereignty, resource scarcity in a changing climate, and the ethical boundaries of human-AI collaboration. But we enter that future with a century of data and experience. We know what works. We know that the human witness is irreplaceable. We know that transparency is the antidote to fear. And we know that the middle ground is not a place of weakness, but the most courageous territory a human being can occupy. The century of conflict resolution has taught us that the goal was never to eliminate conflict, but to use it as a bridge to a deeper understanding. Whether you are navigating a personal transition or a national crisis, the path remains the same. It starts with the disclaimer that there are no guarantees, continues through the hard work of transparent disclosure, and ends with a shared agreement that honors the past while protecting the future. But as we look toward the horizon, a new and even more complex question is beginning to emerge. We have mastered the art of resolving conflict between people. But as the boundary between the physical and digital worlds continues to blur, how will we resolve the conflicts that exist within our own augmented identities? As we move into the 2030s, the battle for the internal middle ground is beginning. In our next masterclass, we will explore the psychology of the augmented self, looking at the next great frontier of human resolution. The century of the table is ending. The century of the mind is about to begin. Stay with us as we continue to map the future of the human experience.